Okay, ready? 1, 2, 3. Hold on now. Wait a minute, fellas. Wait a minute. I think it goes something like this. Whoa. 1, 2, 3, 4, 5, 6. Can somebody take these burdens off of me? Off of me. Can somebody take these burdens off of me? Off of me. Cause every time I turn around, there's something trying to keep me down. Can somebody take these burdens off of me? Off of me. Whoa, can somebody take these burdens off of me? Off of me. Can somebody take these burdens off of me? Off of me. When I look up, don't you know, burdens knocking at my door. So won't you come and take these burdens off of me? Off of me. Oh, come and take these burdens off of me. Off of me. Somebody come and take these burdens off of me. Off of me. Soon as I get up off the ground, my burdens knock me right back down. Can somebody take these burdens off of me? Off of me. Somebody take these burdens off of me, off of me. Somebody take these burdens off of me, off of me. Somebody take these burdens off of me, off of me. Well, off of me, off of me. Oh, off of me, off of me. Well, off of me, off of me. Get them off of me, off of me. Come and break the chain. Come and break the chain. Off of me. Get it off of me. Off of me. Get it off of me. Off of me. I need somebody. I need somebody. I need somebody. I need somebody to get this burden. To get this burden. Can somebody take these burdens off of me?
Just in my rehearsal room. Hold on, hold on, hold on, hold on, hold on, hold on, hold on. Everybody hold on. Hold on, hold on, hold on, hold on. Robert is coming home. He's coming home. Hold on, everybody hold on. Robert is coming again. He's coming home. Hold on, everybody hold on. No matter what they say, no matter what they do, no matter how it seems, God's got the final say. It doesn't matter how long it may seem, the end is what matters. But God's got the final say. So hold on, everybody, hold on, hold on, hold on, hold on, oh, hold on, hold on, for Abba, hold on. The enemies may hate, they can tell all lies. No matter how long, the truth will prevail. They can rise up against all the friends that stand up for him. The end will justify, for God has the final say. Oh, no, 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 yo. Hold on. Hold on, hold on, hold on. Robert is coming home. is coming back. So hold on, all fans, hold on, hold on, hold on, hold on, hold on. Hold on, hold on, hold on, hold on. Help is on its way. Heaven is down here. Hold on, all fans, hold on. God is here, taking it over. Hold on, everybody, hold on, hold on, hold on, hold on.
Hey guys, I came back to read this motion that the government submitted at 11:54. I think they submitted this 11:54 this evening, right before the midnight hour. So I'm gonna go ahead and read this because I think most of my readers are knocked out. But anyway, let's go. I stayed up just to get this out to you guys. All right, I'm not going to go read the top. I'm going to start with the Dear Judge Donnelly. Dear Judge Donnelly, the government respectively submit this letter in opposition to defendant's April 5th, 2022 motion for reconsideration of the court's order denying in part the defendant's motion to adjourn his sentencing, CECF number 285. Specifically, the court denied the defendant's motion to adjourn his sentencing for the date after his trial in the Northern District of Illinois. Pursuant to the court's April 5th, 2022, April 5th, 2022 electronic order. The defendant is currently scheduled to be sentenced on June 16th, 2022 at 10:30 a.m., more than 8.5 months after jury found the defendant guilty on all counts. Reconsideration of the court's decision is not warranted. First, proceedings with the defendant's sentencing prior to his NDIL trial does not violate the defendant's Fifth Amendment right. The Fifth Amendment provides in the relevant part that no person shall be compelled in any criminal case to be witness against himself. As the Supreme Court has long held, this this prohibition may not only permit a person to refuse to testify against himself at a criminal trial in which he is a defendant, but also privileges him not to answer official question put to him in any other court proceeding, civil or criminal, formal or informal, where the answers might incriminate him in future criminal proceeding. Minnesota versus Murphy, 465 U.S. 420 426 1984. Internal quotation mark omitted. The potential statement at issue here involves the defendant's provision of information to a private mitigation expert hired by his defense counsel. Whatever information the private mitigation specialist would potentially provide to the court would not be based on any compelled statement of the defendant. Indeed, the defendant is not being compelled to say anything he is potentially choosing to do so. That is, of course, his choice. But while the Fifth Amendment shields a defendant from the consequences of his compelled statement, it is not a sword that allows the defendant to benefit from volunteering choice to make statement without any conceivable risk. Indeed, this choice is faced by all convicted defendant when they decide whether and to what extent to provide information to a probation officer preparing their pre-sentence investigation report regarding the offenses of conviction, particularly those like the defendant convicted after trial who intend to file an appeal. As the Court of United States versus Davis observed in denying the defendant's request that he be permitted to make statement to the probation department and to the court in connection with sentencing without having such statement used except in the sentence proceedings, in order to preserve his right to a meaningful appeal. The defendant exercised his Fifth Amendment right in the trial and declined to testify. He is still entitled to the Fifth Amendment privilege at the time of sentencing and can decline to make any statement. On the other hand, the defendant is entitled to speak on his own behalf in connection with sentencing. He is entitled to address any comments to probation department and to the court, which he believes will assist him. If the defendant chooses to speak, if he should make admission of guilt, or should make false statements, certain consequences may follow. There is no basis for the court to insinuate him from such consequences. And they give a footnote. It's a court case, and it's still a footnote. Notably, the defendant expressed concern here is even further removed. Statement made to a mitigation specialist retained by the defendants as inherently less risky in this regard than statement made to a probation officer during pre-sentencing interview or to the court at the sentencing proceedings. Defendant counsel will undoubtedly have the opportunity to discuss any statement made by the defendant to the mitigation specialist with the specialist prior to any disclosure to the court and will be able to review any report prepared by the specialist prior to making a decision to submit any or all of the report to the court. Moreover, as noted in the government's response to the defendant's original motion to adjourn sentencing, the same alleged concern about future use of potential incriminating statements made to a mitigation specialist exists even when only concerning the defendant's case in this district, as such information could affect the defendant's appeal and any new trial sought by the defendant on appeal. CECF number 285 at N1. Again, given that the same purported concern would exist even after the NDIL trial. The existence of the NDIL trial cannot serve as a valid basis to delay defendant's sentencing. Notwithstanding that the defendant's concern does not provide a valid basis to delay his sentences. The government nevertheless proposed a procedure that would address and alleviate those concerned, namely allowing the defendant to file any mitigation report or to relevant portion of it under seal and issuing an order prohibiting the government from disclosing the report to anyone involved in the NDIL prosecution. The defendant simply asserts without any discussion that the proposal does not sufficiently protect defendant's Fifth Amendment right. Defendant moked at 2 N2, as discussed above. However, proceedings with the defendant's sentencing does not violate the defendant's Fifth Amendment right, and the defendant's bald assertion to the contrary is not sufficient basis to delay his sentencing, particularly whereas here there is a way to ensure that any potential incriminating mitigation statement made by the defendant that he wishes the court to consider at sentencing could be provided to the court without risk that such statement will be used by the prosecution in NDIL. Finally, the defendant asks is not a small one. See defendant motion at 2. Whether the defendant like it or not, his accusers are victims of serious crime and have right under law. Those victims have the right to be reasonably heard at a public proceeding and in the district court involving sentencing, and the right to proceeding free from unreasonable delay. And furthermore, where the court is granting the defendant request, the government anticipates that the defendant will make additional requests to delay defendant sentences on precisely the same legally baseless ground, given that the defendant also faces criminal charges in state court of Illinois and Minnesota. Moreover, the court cannot predict whether or unforeseen development in NDIL case will delay the trial, therefore, an unknown period of time, requiring the defendant's sentencing to occur after NDIL trial and as any other as yet unscheduled trial in the defendant's pending state cases to address defendant purported Fifth Amendment concern is simply not reasonable in this circumstance. Respectively submitted, Breon Pierce, United States Attorney. You know what, y'all? They didn't say much of anything, did they? We wasted time, wasted sleep on nothing. They didn't say anything. They didn't say anything, y'all. They didn't say anything. Wow. We lost sleep for nothing. Nothing. They said nothing. Absolutely nothing. They said nothing, y'all. Nothing. They didn't put down anything that would. Can we get? Look at Shannon said those dirty bastards. They didn't say anything. They said absolutely nothing. They didn't address the acquittal. They couldn't address the acquittal. They only could address the sentencing because they don't get the last say of the acquittal. They didn't say anything. But he didn't plead guilty. Listen to this. They gave a case, like the case that they gave, right, where the court refused to grant continuing sentences where defendant, following his guilty plea, Robert did not plead guilty. What in the world? He didn't plead guilty. They said United States versus De La Paza, 698 F2D 695, 696, and 697 in the Fifth Circuit Court, 1983, affirming district court refusal to grant a continuance of sentencing where defendant following his guilty plea for firearm defense, requesting a continuance because he could not adequately exercise his right to advocate because an indictment for a continuing criminal enterprise was pending against him. The information wished to mitigate his sentence and firearm violation must be used again. Y'all, they gave the wrong case. They gave a case where someone plead guilty. Robert did not plead guilty. This is so stupid. Why would you put that in there? And then they go say, "Oh, if you give him this now, then he's gonna ask for extension because it's state cases, and there's no time frame for the state cases." No, she asked just for the Northern District of Illinois. She didn't ask anything about the state cases. I think they were tired and they were trying to rush to get something in. They said absolutely nothing. Nothing. Wow. So can you read the judge response where she denied? What? Can I read the judge appeal? Wait for the, wait a minute. So we just made to wait for appeal. Might have to wait for appeal. Can a judge, they violated his, the old new rate? Huh? I don't understand the question. So we may, so 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 mad we have to wait for the appeal case. She can get that one. They violated in every way here old. But the judge hasn't ruled on the other thing yet. Donnelly don't care. She still side with the prosecutors. Exclusive. You heard the government response here first. How many? Let's see. How many did they give ammunition instead of trying them to like the other cows? Sit down, government. Judge already gave them until June for sentencing. You made those old white judge tired. Yeah, they only see. Hold on a second. Hold on a second. Hold on a second now. Hold on a second. I'm trying to see something. Hold on, hold on. Oh, sorry. Sorry, guys. Thank you. Allergies still acting up. I'm trying to check. I don't know why it's a problem with her. I see, I see judges giving continuance on cases on the federal thing here, so I don't understand what the problem is. My sinuses. I don't even understand what's the problem. A couple of weeks. I don't get it. What difference does it make? I'm trying to see. It says here, Judge, do not grant continuance freely unless proceeding to trial would violate the defendant's rights. They have the discretion of denying continuance unless the law where the state required continuance be granted in certain situation. Okay, hold on a second. I was just trying to check something out. Just trying to check something out as far as the continuance. What circumstances? Let's see. I just don't understand why they're opposing a continuance just for the sentencing. I don't get it. She gave, if she can give the 30 days, she can give the extra weeks. It's crazy. Let me see the reason why she denied the continuance. Hold on a second. Let me go back and read the reason why she denied it the first time. The judge denied the continuance. Let's see what she said. And go back and read the reason why she denied it. Let's see the reason why she denied it the first time. She didn't tell the reason why she denied it. Okay, let's see. You know what? The judge didn't write why she denied it. She didn't write why she denied it. She did not write why she denied it. Let me see why she didn't deny it. Hold on a second, y'all. Trying to see why the judge says she denied it. Let's see, if she didn't reply why she denied it, that's a problem. Let's see why she said she denied it. She said the order granting partial part of and denying part. The motion consents continuance for Robert Sylvester Keller. Court denies the application to adjourn the sentencing until after the completion of because of the precedence. But she didn't tell why she denied it. Y'all, she didn't tell why she denied it, y'all. The judge didn't put down why she denied it. I wonder why she didn't put down she denied it. I wonder why she didn't, because normally she put down why she denied it. You can't just deny it without telling why. Nope, the judge did not put down why she denied it. The judge did not put down why she denied it. She didn't explain why she denied it. She did not explain why she denied it. That's strange. That's pretty strange. That's very, very strange. She shouldn't tell why she denied it. Something like that, you would have to explain why you're denying it. It can't just be because I said so. It has to be a reason why you deny it. Is it because the time? Am I catching a cold? No, it's my allergies. It's the pollen out here. I'm scratching my throat and everything. And she still has not replied to the other part. The judge has not replied to those two things. She's going to explain it afterwards like she did the last time. That's what you're saying, perspective. But anyway. In God's perfect timing, guys, in God's perfect timing, this is the time for us to trust God. And there's something. The government is directed to respond to Defendant 285 for consideration. I would think they would have a hearing to discuss this. Why? Mm-mm. We were all questioning her move. I think she did that to cover her butt. Yeah, because they have to. She's supposed to be crossing all her T's, dotting all her I's. Okay. All right. Good night, good people. Good night, good people. I'll see you guys in the morning. Nighty night. Gotta go to bed. Night night. I just came on to do this and now I'm going to bed. Good night, everybody.